All right, good morning.
Good morning, Judge.
We'll go on the record. Who do we have for the state?
Jennifer Gonzalez, Gonzalez.
Today, McCoy Cummings, Tene, McCoy Cummings.
Assistant State's Attorney Anne McCord, MCCORD.
Okay.
Thank you. Judge Nicole Blank-Becker on behalf of Mr. Kelly.
Rayed Shalabi, Raed Shalabi, on behalf of Mr. Kelly.
Steve Greenberg on behalf of Mr. Kelly.
All right, and the record will indicate Mr. Kelly's present in the courtroom. Before we start, I just want to thank the Marshal Service for accommodating the court today. After the last court date, I received a call from the Marshal's office indicating that they would accommodate the court and have Mr. Kelly brought over on each and every court date. So I wanted to thank the Marshal Service for that accommodation to this court. All right, with that, where are we at first as far as discovery, or what do you have?
As far as discovery, we did tender today the bulk of the documents that will come from the Chicago Police Department. There are some materials that are outstanding from the Chicago Police Department, as well as some 417 materials from the lab. And we have a disk of the 2002 file that we're going to copy and tender. So I believe on the next court date we should be complete.
Okay.
The 2002 file, meaning the court file or everything?
Are the reports.
Okay.
Okay. All right. Okay, then what do you have as far as discovery? Any issues regarding discovery that you want to bring to my attention before we get to the bond issues with these motions?
None at this point, Judge. I mean, we're obviously still going through all of the materials, and with the other two federal cases that are out there, we've been inundated with the materials. So
Okay.
we're going through all of it.
All right. I guess the next issue that we have is the, first I'll deal with the state's motion, which they filed prior to the last court date to increase Mr. Kelly's bond. The state filed their motion. The defense filed a response to the motion. Do you have anything in addition to what you set forth in your motion to increase the bond?
Not really an addition, Judge, just the fact that when the original bonds were set on the 4 cases, the court that was setting bond wasn't aware of all the other charges that have now since been filed, both in the Northern District here in Chicago, the Eastern District of New York, and then also up in Minnesota. And so I wanted to make the court aware that the defendant has now been charged with sex charges, multiple additional sex counts in all these jurisdictions, and that should affect what the actual bond is being set in this case. And that wasn't known to the court when we did our bond hearing.
Okay. All right. Mr. Greenberg?
Judge, the first thing I would indicate, although it's not in our written motion, is it's not verified. There's no verified motion to increase bond, which the statute requires.
Okay.
The second thing is there's no legal basis that's cited by the prosecutors to increase the bond. The mere fact that someone may have been charged with other cases in other jurisdiction is not a basis to increase bond. It's not a basis under the statute. It's not a basis under the case law. They don't argue that he's an increased flight risk. They don't argue that he's an increased danger. They don't argue any reason in their motion why bond should be increased. The bond in those other matters has been addressed by the judges in those matters. As the court knows, he's being detained on both of the federal cases. We intend to ask the courts to reconsider those orders. We filed a motion in the Northern District, and we're filing a motion in the Eastern District of New York for that. Should the federal court modify those orders, I fully expect that he will be put on some kind of house arrest, electronic monitoring, GPS, or something like that, which also means that he's not a flight risk. He doesn't have a passport. He's not a danger to others. There's nothing in these other indictments or in these other allegations to show that he's a danger to others. All of the allegations predate these charges, predate the bringing of these charges by years and decades. I would point out also, Judge, that when the state added charges before Your Honor, they didn't ask that the bond be increased. The fact is that Mr. Kelly has never missed a court date, never missed one on this case, never missed one on the prior case that he had, voluntarily turned himself in originally on these charges, voluntarily came to court when the charges were upgraded against him. And there's simply no legal basis to increase the bond in this case.
Okay. Any response?
I would just say that a lot of what counsel just said is based on speculation about what could happen if his bond were changed in one of the other courts. And so that's a lot of speculation. I would also point out that part of his charges here in the Northern District of Illinois include the fact that the defendant is accused of having influenced the witnesses on that case, that first trial. And lastly, I would say that the defendant does have additional charges, and that absolutely is appropriate to bring before this court to ask that his bond be increased. He does have additional charges.
Okay. All right, look, as a practical matter, he's being held now, no bail, in the Eastern District of New York and in the Northern District of Illinois. Unless Mr. Greenberg can convince both of those courts that he should be released on bond, Mr. Kelly's going to remain in custody. So as far as a motion to increase the bond, I don't believe it's appropriate at this particular point in time. That being said, if there's a change in circumstances, in other words, if you're able to convince both of those federal courts in those different jurisdictions that he should be released on bond or some type of conditions regarding release, if you want to bring that motion to increase the bond back before the court, I think that would be appropriate. But at this particular time, it's kind of a moot point. The bond that was set originally in this matter by the, I'm assuming the bond court judge, or maybe from the grand jury, I'm not sure. Bond court? Okay. I thought when the case first came before me for arraignment that the bond was adequate based upon the fact that there's 4 cases, there's $250,000 D bond on each one of the cases, plus pretrial services, which I thought was appropriate based upon the information that I had regarding Mr. Kelly. I still believe that's true. That being said, I'm going to deny the motion at this particular point in time. If there's a change in circumstances and he is somehow released from custody and you want to bring it back before me, I'll take a look at it then, okay? Along that, as long as we're talking about that, there was an order issued regarding pretrial services. In light of the fact that Mr. Kelly's in custody, I'm going to vacate that order here in Cook County. And then, like I said, we'll take a look at it again if he is released on bond. Okay? All right. The final issue I have regarding bond is a petition, or a motion rather, to intervene filed on behalf of the surety. And Mr. Collins, would you just identify yourself for the record?
Yes, Judge. My name is John Collins, J-O-H-N-C-O-L-I-N-S, on behalf of the surety, requesting leave to intervene in this matter and present a motion to Your Honor.
All right. I'll give you the opportunity to file your motion and intervene for the limited purpose of arguing on behalf of the surety that you want the bond returned.
Judge, I don't know if counsel is ready to argue today. If they need a little time, I filed it Friday, so I do understand that they might have more time to respond. If not, I'm prepared to argue today.
Well, it seems to me, in just looking at the motion,
Yes.
that the only response that the defendant may have is whether or not he wants to agree to exonerate the bond, which means that he would be held no bond.
And again, I understand that they are trying to petition in Northern District, Illinois, and in New York. However, Judge, the petitioner is in fear of jeopardy of losing this bond. Judge, as we understand, I think there may have been a CBR placed on this bond, and there's monies owed, so we want to try to stop before and let the court know at the earliest moment that we expect to receive these monies back.
Okay, the only question I have is what authority do you believe that the surety has to come in and request that I do that?
Well, Judge, there's been a substantial change of circumstances. Just like when there's a change of circumstances to increase the bond, Judge, in this instance, he's held no bond, so the purposes of the bond are frustrated in Illinois. And with that being said, Judge, the surety had no basis of knowledge for the additional investigations. It was for this purposes only. So if bond is to be frustrated and he's to be held no bond, then there's no need to have her money sitting in deposit. So if they want to have an opportunity to address that, maybe some modifications to the other jurisdictions' bonds, but this case, this money in these instances were expected to be for this purposes. With bond being frustrated, the court has the ability to address bond in its own right. You didn't increase the bond in this instance, however.
But this is a different issue.
Yeah.
You're asking on behalf of the surety that I return the bond money. And I'm asking you, by what authority are you asking that?
Judge, if bond is frustrated, or if he's not being, if the purposes of bond are not being met, then the court has an option at its discretion, Judge, to order the defendant held with no bond in this instance. If he's going to be held no bond in 2 other jurisdictions and have this bond here waiting, then the entire purposes of bond are frustrated. So we can actually let you exonerate it. It's allowable under the statute. If you want additional specific instances, we can provide those, Judge.
Well, let me ask you this. Your client,
Yes.
okay, is Miss Veronica Love. Is that correct?
Valencia.
I'm sorry, Valencia Love.
Yes.
And she's the surety. She signed the bond slip, correct?
Yes.
Okay. And did she read the bond slip?
Yes.
She did.
Yes, as far as I understand.
All right. If you look at the bond slip, it's clearly stated under notice to person providing bail money other than the defendant. And there's 4 points.
Yes.
All right? And point 1 is, I understand that the money that I have posted is for the bail for the defendant named in this bond in the above numbered case or cases. Okay? Paragraph 1. Paragraph 2, and this is most important. Paragraph 2. I understand that even if the defendant follows all court orders, that this money may be ordered in the judge to pay for the defendant's attorney's fees, court costs, fines, fees, and restitution to the victim, and that I may lose all of my money. That's italicized for emphasis. Third, I understand that if the defendant fails to comply with the conditions reflected in the bond, I may lose all my money should the court enter the forfeiture of bail order. Again, I may lose all my money is also italicized. Yeah. And then the 4th point deals with the 10% of the bond. But my point is this, that when your client signed this surety on behalf of Mr. Kelly, right next to the signature, these conditions are set forth. So, I mean, there's a certain risk that a surety has in signing a bond slip for someone, on behalf of someone who's in custody. She took that risk.
Judge, notwithstanding the language on that, we still ask that in the issue of fairness, Judge, Mr. Kelly is a man of massive resources. This is a private citizen that comes for a limited purpose to assist. And in the interest of what fairness is, she didn't know that New York was going to indict. She didn't know that Minnesota was going to indict. She didn't know that Northern District of Illinois was going to indict. And then those changed the circumstances where, as part of paragraph 2, Judge, Mr. Counsel was representing Mr. Kelly prior to the posting of said bond. So that was hard to see how that could anticipate, how he anticipate someone posting bond and using those resources to cover his fees. So what we actually just say, in the interest of fairness, if he's not going to be released on bond in this instance, exonerate the bond. And it's not an uncommon practice if someone's custody status is
That's a decision made by the defendant. That's not a decision made by the surety.
I understand.
That's made by the defendant.
I understand.
Okay? And the money is posted on behalf of the defendant by the surety.
I still think sureties, and I can find the statute, I think sureties have a right to say if there's a change of circumstances or he doesn't comply with that, they can raise and say, hey, I'd like to have that money back. I don't think it's...
I'd like to see that, because I've never run across that. And I think of what that implies. Think of what that implies if what you're saying is true. The implications are that any person who posts the bond on behalf of another, all right, if they don't like what's going on with the defendant or the particular circumstances, they can come into a court and ask that the bond be exonerated because they feel that things aren't going the way that they thought that they would. That contradicts completely what's in the notice to the surety on the bond slip at the time that Ms. Love signed the bond slip.
Judge, when that bond slip was being signed, in the halls of the Cook County Jail. I don't think that she took the time to have legal advice. I think that we can raise these issues, Judge, and the fact that there's any surety with a request on it doesn't like to change the way that the case is going. That's not the instance here. The
What,
instance here,
what-
the purposes of the bond are totally frustrated, and it seems like it's going to be a big grab at it when it wasn't initially agreed upon. So if the court would like additional information, I can present that and we can set it down for additional hearings where the court can be persuaded that.
I'm not going to go down that road right now. I'm going to deny your motion. I'm going to deny it. I don't believe that there's any basis for it, so it'll be denied.
Judge,
If you have anything else in the future and you want to bring it, I'll take a look at it. But right now, you haven't really presented me with anything that, and in fact, I believe that the law is contrary to what you're telling me. But I'll take a look at something if you have something.
well, if it appears in the future that I have something different,
Sure.
I would
You can always ask to come in again on a petition to intervene.
Thank you, Judge.
Okay? All right, what else do we have today?
Judge, I think the only other thing is that Mr. Kelly is willing to waive his appearance on the next court date and any future date unless something substantive is going on. I know
Okay, well, let's figure out first what our next court date is, okay?
state had suggested December 4th.
Okay. I would be inclined to give it a longer date, based upon the fact that we have discovery with 4 cases here, and then I don't know what the implications would be with the discovery that you'd receive in the Eastern District or in the Northern District as far as this case is concerned. So I think that, in order to make sure that, you have adequate time to sort of look at that, I would be willing to give it a longer date.
Yeah, that's fine with the state.
Okay? All right, what date are we looking at?
All fours.
December 4th?
Yes.
Okay. I'll indicate by agreement on all 4 matters then to December 4th. And Mr. Greenberg, you want me to waive Mr. Kelly's appearance?
Please.
All right.
And if that changes, Judge, then we'll come in and.
All right. I'll waive his appearance on December 4th, and then we'll...
I would point out, Judge, if we are successful in getting him admitted to bond in federal court, he will be here on that date.
I imagine you'll be in before that. Okay. All right. Then by agreement to December 4th. Thank you.
Thank you.
Thank you,
Thank you,
Judge.
Judge.
All right. Court's in recess.